The Bank of Toronto v. Lamba, 1887, 12 AC 575 referred to. It is not for the courts to enter into the wisdom or policy of a particular provision in a constitution or a statute, that is, jor the constitution makers, or the parliament, or the legislature, but it is well settled that the real consequences can be taken into account. While judging width of the power, the court cannot ignore the consequences to which a particular constructalton can lead, while ascertaining the limits of the provisio annans granting the power. The amending body has been created by the Constitution itself. It can only exercise those powers with which it has been invested, and if that power has limits, it can be exercised only within those limits. Article 368 cannot be so amended as to remove these limits, nor can it be amended so as to take away the voice of the states in the amending process. If the Constitution makers are inclined to confer the full PCWC1 of a constituent assembly, it could have been easily provided in suitable terms. However, the original power was limited to some extent. It could not be enlarged by the body possessing the limited power, that being, new constitution or alter or change the essential elements of the constitute rupture. It cannot be overlooked that the basic theory of our Constitution is that pouvoir constituent is vested in the people and was exercised for and on their behalf by the Constituent Assembly for the purpose of framing the Constitution. J. The true distinction between controlled and uncontrolled constitution lies not merely in the difference in the procedure of amendment, but in the fact that in controlled constitutions, the Constitution has a higher status by whose touch stone the validity of a law made by the legislature and the organ set up by it is subject to the process of judicial review, where there is a e.g. Constitution which adopts the Iranbull of Smerenti and the people then is firstly no question of the law-making body being a sovereign body, for that body possesses only those powers which are confirmal on it. Secondly, however representative it may be, it cannot be equated with the people. This is especially so where the Constitution contains a Bill of Rights, for such a bill imposes restraints on that body. That is, it negates the equation of that body with the people. The meaning of the words amendment of this Constitution as used in the Article 368 must be such as accords with the true intention of the Constitution makers as ascertainable from the historical background, the preamble, the entire scheme of the Constitution, its structure or framework, and the intrinsic evidence in various articles including Article 368. It is neither possible to give it a narrow meaning nor can such a wide meaning be given as will enable the amending body to change substantially or entirely the structure and identity of the Constitution. The concession by the respondents that the whole Constitution cannot be abrogated or repealed, and a new one substituted, supports the conclusion that the widest possible meaning cannot be given to it. Bribery. Commissioner V. Pedrick, 1965, AC 172, 193, 94. Rhode Island via Mitchell Palmet, 64. Lead 946, Dillon VRW Gloss, 65, Lead 994. United States via William H. Sprague, William Howie, 75, Lead 640, 644. Howard Osiph Whitehill, 19, Lead 228, and Howie E.V. Smith, 64, Lead 871 referred to. There is ample evidence in the Constitution itself to indicate that it creates a system, OI checks and balances by reason of which powers are so distributed that none of the three organs can be CCOJ, nay so predominant as to disable the others from exercising and discharging powers and functions entrusted to them. Though the Constitution does not lay down the principle of separation of powers in all its rigidity, as is the case in the United States Constitution, it canvasses such a separation to a degree as was found in Rana Singh's case. The Judicial Review provide expressly in the Constitution by Article 2, 26, and 32 is one all, the features on which hinges the system of checks and balances. Apart from that, the necessity for judicial decision on the competence or otherwise of an act arises from the very federal nature of a constitution. The function of interpretation of a constitution being thus assigned to the judicial power of the state, the question whether the subject of a law is within the ambit of one or more powers in legislature AJ conferred by the Constitution has always been a question of interpretation of the Constitution. It may be added that at no stage the respondents contested the proposition that the validity of a Constitution amendment can be the